Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Cison. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Cison.
Hi, everybody, and welcome back to the Third Fridays podcast. It is July of 2026. We're more than halfway past the year. Another one, it is a scorcher out in New York, New Jersey, and we hope you're indoors as you're listening to this. And a lot of the things that we like to do here are very theme-oriented, and this month is no different. We have a lot of our focus this month is on loss of wage earning capacity, and it is one of those issues that you think that you plan for it, and exposure just goes through the roof. So I thought, can we think about how to defend that type of claim, not just the day before a trial, but when we first start to think about that type of exposure. So I thought of bringing on a guest who's here for the first time ever. So welcome, Zaraya Wade.
Hi, Christian. Thank you for inviting me to join your podcast today.
Yeah, and congrats are in order. You recently made senior associate at the firm, so I know you've been putting in a lot of work, and it's a well-deserved promotion. Really glad to have you here today. And I thought of you because, when, we don't do too much work together, you and I, but everything I hear about you has to do with like your fierce advocacy, your litigation prowess as an attorney. And so, I thought who better to bring on and talk about a claim that really requires advocacy from start to finish. So I know you have a lot to talk about this particular issue. So I'll kick it off to you. Like, where do you want to start as far as, a client has a claim that has potential loss of wage earning capacity exposure. What is the first thing you do or you think about or you prepare for or you discuss with your paralegal, your adversary? What are the things that are the building blocks in your mind?
So I begin building my defense as soon as the claim is referred, so that I am as prepared as possible if this matter proceeds to trial. When considering a loss of wage earning capacity claim, the judge considers three main factors: the permanent medical impairment as assessed by medical professionals, the injured worker's post-injury functionality, and their vocational history. So upon claim referral, I am requesting the personnel files. I am requesting an ISA report to explore whether there were any prior injuries. And I am scanning the medical impairment guidelines from the claims referral to see the life of treatment and where we may possibly end up at.
Sorry to interrupt you. I guess that's a really interesting point there in terms of, the three factors that you have there, right? And when I'm interrupting you mostly because when you said I'm scanning the medical, right? Does it make a difference if the file is referred to us and, for handling in like 1 year post-accident or like 1 month post-accident? Like, does your strategy change at file referral based on the length of time that has elapsed since the accident?
For me, it doesn't, because it's still a new file to me. And so there are important information in every single medical record, whether there's only 2 records present or 20. Right. I'm trying to ascertain as much information as possible from those medical records. What were the initially reported injuries? Are there new injuries that are being hinted at throughout medical treatment? What the recommendations by the providers are. Yeah, I handled the file aggressively, regardless of when it was referred.
Okay, so I guess I would expect nothing less from you, but so I guess you were talking about scanning the medicals, right? And with those three prongs of loss of wage earning capacity in terms of like the impairment, the functional capacity, and the vocational factors, all three of those could be present as you're reviewing those medical records, right? Like you can see certain things. Which one of those factors do you think is the most important for an attorney to attack in terms of, is there one of the three that you think is most important at the outset? Because, I guess we're still talking about when the file is referred. So we're maybe far away from permanency reports in a trial and you're still looking at it for the first time and you realize you have some LWEC exposure. Which of those three are you worried about the most or trying to prepare for the most?
Personally, for me, it would be the functionality factor.
Okay.
I look to see if the claimant is using any assistive devices, any prescription medication that might impede their ability to operate a vehicle or just like perform any type of employment. I look at the range of motion findings of the injured sites. And I start to consider how that may impact the claimant's abilities to handle daily activities such as walking, sitting, chores, self-care. And if I have access to the personnel records, I'm able to start to consider whether there is a possibility for the claimant to return back to some form of light duty work, if not now, but in the future.
Right, right. And I guess, you bring up the ability to return to work because at some point during the claim, whether it's, in the beginning, middle, or the end, if the claimant has some ability to work, their function isn't, they can't cry foul at the loss of wage earning capacity trial saying I can't do anything forever, right? Because if you can prove that they can do some type of work, they can re-enter the workforce, attach to the labor market. These are the things that, you're stressing in terms of their functional capacity, right?
Correct. And I do genuinely believe that here at Lois, we want the claimants to return back to gainful employment.
Right.
And so something that I love the most about loss of wage earning capacity claims is that it allows the carrier's attorney to kind of be the claimant's cheerleader at the end of the case.
Oh, wow.
A work accident doesn't have to prevent an injured worker from returning to no work at all. It gives us an opportunity to help the claimant see their full potential.
I almost, I'm surprised more because someone who is a defense attorney and as aggressive as you saying that you're the claimant's cheerleader, right, for a case like this, but it is true, right? The idea, the numbers don't lie insofar as the longer that someone stays out of work, and it doesn't even have to be an injured worker, right? Like just someone who stays out of work makes it less likely that they can return to work, right? I haven't been on an interview in years and years and years, but I would imagine that if I had like some gap in employment, maybe it doesn't matter as much now with the way the market is, but I would always be scared that like if I was ever unemployed for so long, right, that people would ask me about that. And so as a claimant's cheerleader, because I kind of want to keep going with that little phrase, and I'm already writing like the podcast blurb in my head now because that's like definitely going to be the phrase. What do you think how do you think that's perceived, right? Because I think from a defense perspective, we are typically looked at by the judges and especially by the claimant's attorneys. Maybe they're putting on a show for the claimant, but we can tend to look like the bad guys. But the notion that you have of being the claimant's cheerleader, do you find that to be well received or poorly received by people that you deal with in these types of cases?
I don't. Although workers' compensation has an adversarial component, we ultimately both want the same thing. We want the claimant to seek treatment and to return to work, whether it is their pre-injury employment or a new employment field that accommodates their restrictions. We both want the same thing.
Yeah, maybe some claimants attorneys might disagree with you in their sleep or in their dreams. They wouldn't admit it. But you're right. Our training materials for new attorneys and paralegals, when they come in, they say that a claim really has two goals, and it's either to return the claimant to work or to settle the claim. Because if we're defending the integrity of employment, we know that an employer has to actually work harder and spend more money and time, blood and treasure to replace an employee, right? That's always been the case. No employer has a ready-made replacement employee that they're paying and doing nothing to just kind of step in, right? So to every time a replacement is made, there's some expense, whether it's monetary, time, things like that. And so if we can have that employee return to the pre-accident position, that's considered a huge win, especially in the case of a loss of wage earning capacity claim, right? You don't have those types of exposures. But I always think about these types of claims as, we prepare for the worst so that our clients get our best, right? And so with these LWAC claims, you're almost, correct me if you take a different approach, but do you ever look at it? Because I know I do it this way. I pretend as if the injured worker might never come back to work. Do you ever have that mindset, or do you kind of go down a different road?
I address every claim with the assumption that this injured worker wants to return back to some form
It's
of
interesting.
employment.
Okay.
And as treatment pursues and it looks less and less likely that they would be able to return back to the pre-injury employment, I start to consider what possible alternatives there are for this injured worker. Once I realize that it may be unlikely that they intend to return to any form of employment, then I start aggressively reviewing the file for settlement.
Okay, that's an interesting point, I guess, because your first thought is, hey, like, if I put myself in the shoes of the claimant, it's not going to make sense for me to stay out of work forever and collect less than what I would make, right, by working.
Exactly. We all have bills.
Right. Like, why would you want to stay home and make less money? I think when you talk about settlement after you realize it's unlikely, I figure that those are the types of claims where the claimant may be positioning the claim for a permanent total disability, right? Because at 2/3 of what they earn in employment, it's kind of similar to what they would earn in employment post-taxes, right? So sometimes claimants make that math problem, something in their favor where they say, well, if I could just not work forever, I can get paid 2/3 of my wages just for being disabled. I think that's where the system kind of requires advocacy, right? Because if everything was black and white, I tell clients all the time, you really shouldn't need us, right? Like, you shouldn't need us for the claimants that are motivated to return to work. And so that's where maybe I'm a little bit more jaded than you are. And kudos to you for staying very positive. I'm now thinking to myself, I have to be more like you in that regard, because I think most of the files that we see are the ones where they are unlikely to want to return to work. But maybe it's because they're getting maybe bad advice, or doctors keep telling them that they can't work even though they can. And there's some kind of, an improper relationship going on between doctor and attorney. We know that there's a lot of like fraudulent relationships going on. So what do you say is your strategy then if you determine that the injured worker is unlikely to return to work, and now you're saying, okay, I want to settle this? How do you, right? Our clients don't say, okay, here's like a bunch of money, throw it at them and tell them to go away, right? What is your strategy to start moving the case in a direction where the settlement figure is favorable, not just for our side, but for both sides? Like, what are the things that you're starting to do at that point?
Okay. So I am reviewing the medical impairment guidelines to start to come up with the estimation of how that might result. I am reviewing all of the medical records again from top to bottom to kind of understand the claimant's current functionality. And I'm using every reliable resource available to understand what the claimant's vocational history may be. I'm reviewing medical records, personnel files, LinkedIn, anything that may provide some helpful information about the claimant's prior work history. And then I'm crafting a settlement evaluation that's curated to this individual.
Right.
Once I receive settlement authority, I'm reaching out and I'm having a very frank discussion with the injured worker's attorney. It appears that your client may or may not be able to return back to employment. This is what the carrier is willing to offer, and these are the things that were considered in crafting this offer for your client.
And that's a very nice jump off point that I'd like to discuss here, because you mentioned having a frank discussion with your adversary. And I feel like, especially for new attorneys, right, you have some arguments that you would plan to make at trial. You know where you stand, where you're going to argue in terms of the impairment, where you are with the functional capacity, where you are with vocational factors. And do you ever feel in this frank discussion that you're having with the adversary that you need to hold back on some of the arguments, like your strong points regarding LWEC exposure or claim dollars and cents? Because, hey, if this doesn't settle, I'm kind of giving him a little, or her a little bit of the kind of recipe for success here against me. Is there anything going through your head as far as that type of, conversation? Or are you someone that gives them the keys to the kingdom in terms of, hey, this is what I have. This is what the case is. I don't care if you know about it, right? These are just the facts of the case. Like, how do you approach that conversation with your adversary?
My approach varies depending on who opposing counsel is.
Oh, okay.
Some attorneys, I will just offer the maximum of my settlement authority to limit the back and forth.
Right. Okay.
This is what I have. I'm not receiving any more money. And the facts are what the facts are.
Right.
For example, there was a case that I had where monolingual Spanish speaker. However, he has significant entrepreneurial experience in his home country. And so although he came to the US and worked as a construction worker, he also knows how to run his own business. He had his own business for 15 years. This is not a permanent total disability claim either. He has functionality. This is what the offer is. And if you discuss this offer with your client and he does not want to take it, then we can proceed to trial.
Right,
but I pride myself on being the most knowledgeable person in the room when it comes to a loss of wage earning capacity claim. I know things about claimants that their own attorneys don't know.
Yeah.
Because I do my research.
Right. And you mentioned, like, hey, this is the offer and that's it. I think more and more clients, in my experience, are starting to be in line with that strategy as long as it's kind of discussed with them beforehand. Like, because, and I mention this to people a lot, that if you get stuck in the same habits of settlement negotiation where you make an offer and then once it's rejected and the adversary gives you demand and you quickly just move up the offer, to me, it feels like sometimes the adversary learns that you're always going to lowball them and move up. And so that varied approach that you are talking about, I think, has had a little bit more development where clients have come to us and said things like, this is the number I'm going to give you, offer it. And that's your one-time offer, right? Like we're serious about this. It's not going to change. It's not going to move up. Or they have a deadline, right? They have until this amount of time to accept it, or we go to trial. And I think that approach helps the art of the negotiation, right? That, every offer means something. And sometimes there are situations where you need to start low and move up. But like, I think the whole point of that negotiation art is that there should always be that justification behind the offer that you're making. And I think it's interesting that you mentioned that frank conversation, because when you make an offer or you're rejecting a settlement demand from the adversary, it actually helps you keep remembering the file. It keeps it top of mind for you. And when you start to have these prolonged negotiations that end up not working out, correct me if I'm wrong, but I think sometimes I feel like I'm more prepared for the loss of wagering capacity trial because I've been negotiating so fiercely in the weeks leading up to it.
Absolutely. The approach that I take is that I build trust with opposing counsel. They believe me when I say this is the maximum offer because I'm not lowballing them.
Right.
And so that has served me well in settling many of cases. I don't want to toot my horn, but I may be the number one settler at Lovis Law Firm.
Well, you know, the thing is that you can't, like in any industry, right? You can't go to another stakeholder and say, this is the fact, and then renege on that fact like a week, right? Like, so it's like, if you tell your adversary that's your maximum offer, you actually can't go back to them.
Correct.
A week later with more money, because then you've actually just ruined your own reputation.
Exactly. That is exactly my position.
So, okay. So, you know, we throw a party, you know, all the confetti's in the air because you've written another great impact statement about settling this big loss of wagering capacity case. I don't doubt you that, you know, because I think you definitely take pride in a lot of the settlements that you reach. It's always a nice thing to read at the end of the day here at the firm when people kind of champion their own impacts and gratitudes for their teammates. But what if the case doesn't settle then, right? So, you know, you're in the week leading up to the loss of wagering capacity trial, and you know, you've done the depositions of the doctors, or maybe should we talk about that? Like, you know, maybe you're in the process of negotiating a settlement, but you're not quite there yet, and you have the deposition of the treating physician coming up. What is the first few questions that you're asking the treating physician? Like, what is the thing that starts off that cross-examination for you? Is it a particular issue within the guidelines for impairment? Is it something about functional loss? You know, is it different all the time? Maybe it is different all the time, but what do you feel like has the most impact? I know I've asked you like 18 questions here in this soliloquy, so feel free to pick one and just run with it. I know I'm just talking circles. So like, really, when you're cross-examining the treating doctor in an LWEC case, what is your main focus?
Comparing their medical reports against the medical impairment guidelines, highlighting any improvements there were with treatment, with the functional position, and also just seeing how much they actually know about this injured worker's day-to-day, their pre-injury employment. It takes the credibility away from a provider who maintains a temp total disability for 3-4 years, but also indicate that there were improvements with range of motion, reduction with spasms and tenderness. So that's kind of my approach, comparing the collective medical reports and the permanency report against the medical impairment guidelines. And just, you know, really drilling, do you know this claimant as well as I know this claimant?
Right? Because I love that.
I've had the benefit of reviewing all of the records. And unfortunately, treating providers do not have that benefit.
Right. You know, my favorite is he was a construction worker. Well, what type? Like,
exactly.
Like, was he on his feet? Was he sitting down? Was he on a scaffold? Was he on the ground? Like, you know, like, I think this type of context matters actually more for loss of wagering capacity sometimes than your depositions in temporary disability land, right? Where you know you're not at MMI yet, and your goal is really just to find some ability to work so you can raise labor market attachment and do all that jazz. Here, where you're trying to focus almost like a science to an art, because you know that the way that the percentage of this loss of wagering capacity sometimes seems to vary based on the judge. It's it's almost like, finding these attack points with the claimant's doctors really have some merit, because sometimes you can use the years of treatment against them, right? Like, maybe they've been treating the claimant for 3 years, but they've forgotten what he's done before the accident. So how can they truly comment on his functional capacity?
Exactly.
Yeah. Okay. So the depositions, we're talking about like comparing it to the impairment guidelines. I think that's a rock solid approach. I really love what you said about, do they know the claimant as well as I know the claimant? Because I know the claimant almost as good as, or maybe better than the claimant knows himself or herself, right? Now you get to the point of the actual loss of wage earning capacity trial, and the record's almost closed in terms of impairment and functional capacity, right? Because the doctors have testified, and now the claimant's testifying to vocational factors. Do you spend more of your time on cross-examination for vocational factors, or is it trying to put together like a summation argument on the impairment and functional loss prongs? Like, what do you focus on when you're preparing for the actual trial?
Well, in addition to reviewing every reliable resource to determine what the claimant's prior history was, I'm asking the right questions. What did you work at for within the last 15, 20 years? What special certifications or skills do you hold? What previous education did you complete? What current education are you pursuing? These type of inquiries help all parties to see a complete photo, a complete picture of the claimant's current situation. So I am spending a lot of time on the vocational factors. I don't take no for an answer. I want to know everything. And I'm already coming into the trial knowing a lot. I'm knowing that you speak some English or you're speaking another language in addition to your primary language. So I do spend a lot of time on vocational history, and it's actually one of my favorite parts about the loss of wage earning capacity consideration is it allows me to be an investigator.
Oh, that's interesting. Because I know a lot of attorneys are fearful of that particular prong, because typically speaking, like there's no calculation, right? There's no mathematical formula for saying, okay, it's once you hit this age, your vocational like factors become aggravating, right? There's no set standard. And so I think a lot of attorneys are fearful, but it's refreshing to hear how actively involved you are in it, especially when, we can harken back to what you mentioned at the very beginning of this podcast was, I want to get the employment personnel file, because all of a sudden, you have the claimant's resume, you have the job duties that they did before the accident, and now you have work restrictions from both doctors at this point. If the claimant isn't aware that you have these documents in possession, he or she may be testifying to vocational factors that might actually give you a fraud claim, which is
Exactly.
It kind of ties everything together. I didn't expect you to kind of bring it all together, but when you talk about the interest you have in the vocational factors, how often do you feel, and I don't want to say that every claimant is like this, right? But because some claimants, they testify truthfully about, their skills and certifications. I don't want to be that person who says everyone is a stick in the mud. But, how often do you think like it occurs where you get a personnel file from the employer and then the claimant testifies to vocational factors that are inaccurate? Do you feel like that happens often, not often? What's your take on that?
In my experience, I believe that claimants don't lie about their prior history. They just don't disclose it on direct examination. And so once I start asking
interesting
those
lawyer
questions,
words. They don't lie, but they don't disclose it. Okay. All right.
But once they're questioned about it on cross-examination, I find that people are forthcoming about their prior work experience and their history.
Okay. All right. That's, I think I think that actually helps your case, that you're not quick to judge the claimant as a liar under oath, because sometimes, judges get the feeling that they think that's what we're all about, that we're trying to trap them into a lie. But in reality, failing to disclose something, even if it's not considered a lie by the judge, does impugn credibility. It does impact like how they're moving the claim forward. And so I think that's a very interesting take that, if it's not a lie, it can still be helpful to your position because you've done the due diligence in the background to say, Judge, the claimant didn't disclose that he has a certification in XYZ, or she actually did graduate college because my employment personnel file and the resume shows that she has a bachelor's degree, right? So those kind of things can tip the scales, I think, even more emotionally in the defense's favor, because I think people just want to reward the truth, right? That's exactly why the law exists. So very interesting take there. And now I want to get to the end here, right? So you've done the cross of the claimant's doctor. You've done the cross of the claimant. You're summing everything up, right? And how do you come to a particular percentage of loss of wage earning capacity? And we know that it's a little bit scientific in terms of the crosswalk and trying to approach a letter ranking with a particular percentage. But after that, science truly just becomes art, where it just becomes all over the place. How do you get to the point of putting together the final LWEC percentage to argue to a judge?
So just to piggyback off of that, after reviewing and assessing the claimant's functionality and hearing how the claimant is also describing his own functionality, I consider, would this be considered a neutral factor? Would functionality be considered neutral? Would it be considered aggravating if he's significantly limited in self-grooming activities? And I also take that same assessment with vocational. For me, as long as a person is not 90 years old and they've had some type of employment history, those skills are transferable.
Right.
And luckily at Lois, we work with a lot of great carriers who also offer vocational services to injured workers who actually want to return back to work. And so I never really consider vocational factors in history to be aggravating. As long as you're alive, you have some use of your limbs, you can speak, whether that's in English or in another language, we can find you an employment. We can find you a job.
Yeah, 90-year-olds have smartphones now too. So,
they do. And they know how to use the computer.
Right. They know how to use computer. I would imagine that ChatGPT is helping them do a lot more things these days. It's definitely a situation where, if you can make it neutral or even ameliorating, right, you have a better chance of making the loss of wage earning capacity closer to what the impairment is. Because even though the case law says you can't directly translate disability into loss of wage earning capacity, I think that's where the fear is for some, especially inexperienced attorneys, is, well, if you can just do whatever you want with this, like, shouldn't we be scared? And I think something very refreshing about your entire vibe today has been, well, shouldn't we be excited, right? That you can do a lot of things with this. And that's really something that we need to be more, I guess, aware of, right? About how positive we can be as defense attorneys in an industry where it seems like we keep having the book shut on us. We keep getting, turned away. The stats are there. We lose more often than we win, but I think the approach and the mindset are truly crucial to really savoring those wins. And so I think it's been a great talk. Any last thoughts from you or any takeaways that you want our clients, our prospective clients, any attorneys and paralegals that are listening to this right now, what do you want to kind of end this on, Zaraya?
I just want to say that our experienced and dedicated team of attorneys and paralegals are the reason that Lois Law Firm has remained so successful in defending loss of wage earning capacity claims. We bring it.
Great way to end it. So for our new senior associate, Zaraya Wade. My name is Christian Cisan, reminding you to defend from day one.